Come
That's the
on.
only chance we'll get.
Yeah, take all the
We
fun
are now
away.
recording. We are on the
This
air,
whole damn meeting.
Okay.
and we're getting close to the start of the meeting.
Hey, Vaughn.
Hi, Yvonne.
Hi, Bob. Hi,
Kurt,
Bob.
Kurt,
Yes,
it's Pat. Can I say a word or two about a need for a caller substitute?
No.
Alexa, stop.
Good. I think that voice was Tom, so you are it. Yvonne, you've got your substitute.
Good to see you, Vaughn.
That was easy.
I know. Thank you, Tom.
Well, I mean, that's a perfect way to segue into the start of our 8th. Do you believe it? Our 8th Zoom meeting. We've been doing this for 8 months. Look at how good everyone's gotten on Zoom. You're all a bunch of Zoom pros. It's really wonderful. And it's so great.
When I speak, do you get my face?
Yeah, we can see you.
Okay.
Okay.
I can't see me, but
Anyway, it's our 8th month of doing a Zoom call, and we have a great speaker today, Bob Valentine, and I'll say a little bit more about him later, but he's really, he's like us. He's got a lung disease. He's a lawyer, and he's taken his valuable time to share with us some thoughts about life and the world thereafter. So he's going to talk about heaven and hell and some of the options in between.
Well, wait a minute. Kurt, there is no hell, remember?
Oh, that's right. There is no hell. Joseph told us that.
Yeah.
But before we go any further, I have to recognize the contributions of your board of directors, because without the board of the directors, there wouldn't be a Zoom call. There wouldn't be a pep talk. There wouldn't be workout sessions at Jackie's gym. We wouldn't have a database. We wouldn't have a website. All of that is done by your board of directors. So I'd like everybody, once again, to give your board a round of applause.
attaboy, attaboy, attaboy.
That's Susan clapping in the background.
Thank you, boss.
I'd also like to remind everybody, if you have complaints or suggestions or whatever, don't hesitate to contact any of the board members or myself and share with us your thoughts or ideas. Our guest speaker will be speaking until 12:15, and then we'll have a Q&A from 12:15 to 12:30. And it's at this point in time when I get to mute everybody. It's my favorite part of the day. I get to go mute everybody. Boom.
Hey, Kurt, before you mute everybody, can I say something real quick about the questions?
Yes, you can.
I have a feeling we're going to have a lot of questions. So if we can just raise our hands, and I'll try and watch as the hands go up and call them in order so we can try and keep it orderly.
Okay, do you all get that?
Yeah,
If you have a question, raise
instead of
your hand.
everyone speaking out, please raise your hand, and I'll try and keep an eye on the order they go up so we can try and keep them in order. Tom?
And Jocelyn, why don't you ride herd on the whole Q&A?
Yeah, I'll
Okay.
regulate.
Because you're
You want this organized?
smarter on this. So I am now going to mute everybody.
Goodbye.
Mute all. Okay. Goodbye, everybody. Except I will ask Bob Valentine to unmute himself. You know, Bob is a lawyer, a very accomplished lawyer. He also has a lung disease, and he's going to share with us his insights, because he specializes in this area, one of the areas that he specializes in getting ready for the day when we go meet our maker. And, you know, it's not just about wills and trusts and all that, which is very important, but also all the little things that you haven't thought of. Giving your kids or your descendants or whoever, key passwords to your phone, key passwords to your, where is the safe deposit box key? All those kinds of things that are so important when you pass on. People are left with, gee, did he have a checking account? Did he have a savings account? All those things that are so important. And Bob's going to share his thoughts and experiences. So it's with great pleasure. And Bob, I know Bob, and Bob is just one of these stand-up terrific guys. So it's with great pleasure that I introduce our guest speaker, Bob Valentine. Mr. Bob,
Hey.
it's all yours.
All right, Kurt, thank you so much. I appreciate the introduction. And we met a few years ago at PEP, and then we saw each other at another function, a dinner, and he came running up to me and he said, "What are you doing here?" And it was a different organization. And so we've got a bit of a connection, and that's really nice. Just a little bit about myself. Who am I? I'm from upstate New York originally. I went to 5 high schools and I went to 4 colleges, and my parents were never in the military service. It was me that moved around. But ultimately I got to California and I went to my last 3 colleges here in California. And then things kind of changed better for me, and I went on to law school, and I actually taught for law for a couple of years, and went into private practice and have enjoyed that immensely. I've had several interesting cases during my career, one of which was a federal case involving the LGBT community and the armed services. And it was tried over a 16-day period in the federal court in Riverside. And I remember the government had 6 lawyers on their side of the podium, and we had 3 on our side. And it was really a very interesting case. And what it did was that it found that it negated a law that prohibited LGBT community from being members of the armed services. And it went up on appeal and so on and so forth. But ultimately, we prevailed. And so that was a very, very fascinating case. And then thereafter, I had a case involving abuse to an elder, financial abuse to an elder. And this is a very, very big thing these days. And the magic age is 65. And that's where the California laws come into play to protect elderly people, defined as people age 65 or older. And in my situation, and it was a friend of mine, but she had kind of isolated, and she got behind in payments. And what happens is when a foreclosure or a notice of default is prepared by a lender, such as a bank, it's recorded with the county recorder's office. And there are people who scour every day the county recorder's office looking for newly filed notices of default. And they get the person's name, the address of their property, and then they can find out a contact number for them, and they will call them up and they will say, as they did with my client, "We're here to help you." And she thought it was an answer from heaven and asked, "How quickly can you get to my house?" And she had a house worth well over $1 million at the time. And she had gotten behind in her mortgage payment. And so they came and they had her sign a whole bunch of papers. And mind you now, she was isolating. And so she wasn't talking to family. She wasn't talking to friends. She wasn't talking to me. She wasn't talking to anybody about this. She was embarrassed. she was ashamed. And she ended up signing over that house for $35,000, you know, to these scam artists. And anyway, ultimately, she came to me and we got involved. And it was one of the first early cases dealing with certain code sections here in California that were designed and are designed to protect seniors from fraudulent activities by other people. And so this case went on for several years, and it ended up, and we were in the 7 digits, well into the 7 digits by the time that case resolved. So it was a very good result. The problem was she died probably 5 days before the money came in, and she was able to spend a penny of that. And ultimately it went on to her family. But it was a very interesting case. We learned a lot. The judge learned a lot as well. And he indicated when he writes his biography, he's going to put a chapter in there on that case. It was that interesting a case at that point in time. But, you know, as people, well, I'm going to say one other thing because I think this is very important and very current. I don't know how many people were totally aware of Proposition 19's effect on so many of us, especially people that live near the coast in California, where property values in homes and other real estate has really escalated and gotten over the $1 million level. But Proposition 19 was on last November 3rd's ballot, and it passed. And the wording of the title of it included aid to victims of wildfires. And yet what that ultimately did, Prop 19, it has had a dramatic effect in stripping away a lot of benefits that Proposition 13 and Proposition 58, both enacted years ago, gave to families, especially when they wanted to transfer real estate from parent to child. That's the Prop 58 aspect of it. And the limitations have been extreme. And I think if everybody affected by this legislation had been aware of the far-reaching aspects and effects, I don't think it would have passed. And it was done in a hurry. It was signed in a hurry to get it on the ballot. And consequently, that hurry approach to it left a lot of loose ends that are going to have to be the subject of further legislation by the state legislature, because people don't know how certain fact patterns might play out. But essentially what it said was this: up until Prop 19, parents could have a home, their primary home, and they could leave it to their children, and it could be of any value at all. Could be $25 million, you know, and the tax base would be based on the assessed value at the time of the parent's death. It would not be recalculated up. Prop 19 said we're only going to allow up to $1 million more over the assessed value as a protected amount. And then everything over that will be reassessed at the then market value at the time of the gift, let's say, or the transfer. So that's a big thing, because there are a lot of homes along, as I say, the beach and the coast here in California, and most especially Southern California, that are worth more than $1 million or multi-million dollars. So that's going to have an effect on a number of people. The second thing that was available before Prop 19 was that parents could also leave up to $1 million each So that'd be $2 million, husband and wife, two parents, of any sort of real estate to their children. And that could be apartment houses, it could be a mall, these small malls we have on large corners, things like that, up to $1 million each parent to children. And again, this is a Prop 58 provision. That was stripped away by Prop 19. So I'll give you a very real example of how this works. A client of mine, when she died, and Prop 19 says, although we're going to allow up to $1 million, to be spared from an uptick on a primary residence, that will only be the case if that child makes that residence his or her primary residence. So it's got to be a primary residence for that child. So if you have multiple children and you leave it to 3 children and one lives there, then it'll only be 1/3 of that $1 million because only one child will benefit and qualify. But a case of mine, in the last year, the lady died. She had 3 children. She left her primary residence to a son, and she left 2 other properties to her 2 daughters. The son lives in another county, wasn't going to come back and live in the primary residence. Yet under Prop 58, prior to Prop 19, he can keep, and there is no uptick in the assessed value. The other 2 daughters, the assessed value of each of the properties they got was less than $1 million each, although the market value was higher than $1 million each. It's based on assessed value. And so there was no tax due there. Today, in February of 2021, none of those kids would have any benefit at all. They would be taking the properties from mother, and the new tax base, real estate tax base, would be based on the fair market value on the date of mom's death, which would be dramatically higher. And it's just, so that caused in my office, my firm, and many lawyers that deal with estate planning and trust and probate and so forth, we were jammed. People wanting to make a gift before the trigger date. The trigger date was last Tuesday. It was the 16th of February. So gifts made before the 16th of February would qualify under the old law, not the new one. And so the 16th of February was a Tuesday. The day before was a holiday, and the Friday before was another holiday. And so the recorder's offices were closed on both those days, Friday and Monday. So that meant it had to be done by last Thursday. And the interesting thing is some of these counties, the recorder's offices are so backlogged in recording documents. In LA County, it's 3 months behind. So that if somebody the day after election wanted to make a gift to their child, and if the key to determining the effectiveness of that transfer was the recording of the deed, they were more than 3 months behind the day after election. It could never have been recorded by February, I think it was 12th or something, last Thursday, week ago today. So those are some things that they're trying to deal with. They're going to try to work out, see what they can do. They're saying, well, maybe we'll just go by the date that it was notarized and delivered to the child, that sort of thing. But that's unresolved yet. And not all counties are on board. So that's an example of why when you look at your estate plan, and I see probably 25 people or more on the thing. If I were to ask you to raise the hands, how many people have their name on a piece of real estate, for example? Okay, and then my follow-up question would be, how many of those people have a trust? Would raise their hand. Good, You're in good shape. Okay. Because you can avoid probate by trust. Trust has a lot of benefits. And among the benefits, there are living benefits. While we are alive, we can benefit from a living trust. And many of us in our situation where we have lung issues, for example, that are progressive and there's not a cure, I'm thinking of IPF particularly, there may come a time where we may not be able to handle our own affairs but we're alive, right? And then there's cases where people have accidents, they're in a coma and they can't do anything. So living trusts say, they usually have a trigger built in, that when the trigger is pulled, then the successor trustee can take over, can step up and assume handling the bank accounts, paying the bills, keeping everything current, and so forth, and knowing where to get things. So that kind of leads in a little bit to what the expression was of what this today would be talking about. How do we let successor trustees know, the passwords to our various accounts? Because we're changing passwords sometimes. I heard, was it Jackie said that every 6 months her employer wants a new password? That's not uncommon. Passwords now, they measure the strength of your password. And so they want something that, has a number in it. It has a capital letter in it. It has some sort of other, like a plus sign or a pound sign. They want some other designation. And then they'll let the agency that is going to be accepting this new password. They'll tell you the strength of the password, how they view it. And as I say, so passwords can be very difficult to remember, even when we create them. I have difficulty remembering passwords. What did I do for this password? Did I use the pound sign? Did I use the exclamation point? Did I put it before, in the middle, after? Did I put 2, 1? And then I write it down. And these are post-its, right? These can be very dangerous in estate planning in several respects. They can be tossed, they can be found. Maybe other people who find them can put together, what account it's supposed to allow access to better than I can remember, being even the creator of it. And just so I don't forget that while I'm on this, these little post-its. When we and people leave items of personal property to family, like pictures, china, jewelry, furniture, often has been the time when people would write the name of Susie or Joe on a post-it sticky note, and they would put it on the back of the picture, and so forth. And I tell people that sounds good, but it doesn't work. Very often, and I have seen this happen, the first sibling or child that gets to the room or to the house, and they see those, and they say, oh my God, my sister got that picture, I want that picture, and they swap post-its, and there's a total reorganization of the distribution of the personal property that can happen with something so fleetingly temporary as a post note. And I say that because I've seen it happen, and not that necessarily you would do it, but I'm just suggesting give it second thoughts if you were to do it. But anyway, estate planning does involve a lot of things, and the whole purpose of it is to provide for the timely and the orderly, private, least expensive transfer of assets to those you wish to benefit, usually family members, but not always, not always. And so in doing that, trusts are probably the most favored method of doing that because they're private. They're not public, they're not subject, they could be subject to court, but they are not automatically subject to a court review or court oversight. And you can amend them, modify them, revoke them during your lifetime while you're competent, and many do. And there's a lot of reasons to pull out your estate plans that might have been made 5 years ago, 10 years ago, 15 years ago, 30 years ago. Pull them out and take a look at them and go over them. Are the beneficiaries the same today that you would name as you had named years ago? People get married, divorced, they die, they have children. They may become incompetent. They may have had a change in financial circumstances. They either need more or they don't need any. And so these are all good reasons to review an estate plan. In addition, a good reason to review an estate plan is laws change. Right now, everybody can die and leave up to $11,700,000 of assets to anybody they want, and there's no death tax on that. And so when you double that, for a married couple, it's $23.4 million. Now, that does not affect 99.999% of the population, but that's what it is today. And that is, right now, that is scheduled to end, that large exemption, on December 31st of 2025. So beginning on January 1st of 2026, that's going to cut by 50%. And there's no saying what might happen even after that. But tax laws do change. And so we have to be aware of those to see if they would impact our current estate plan. Another thing that may change, there's discussion about under the Biden administration, changing the mark to market, or changing the base value of a property, marking it up, as it were, to the date of death value, and using that as a new basis. That's important for income tax purposes, because when you sell a piece of property, there can be capital gains tax on that property. And the capital gains tax is measured on the difference between the sale value and the base value. So if you purchased a property 25 years ago for $50,000, and today you die and you leave that, to a child or whoever, anybody, the new basis would be, and it's worth $2 million today, would be $2 million. And then if it got sold for $2 million, there'd be no gain because the basis equaled the sale value. But if the basis comes out of the law and it says no more markup to market, I call it mark to market. If there is no longer that basis change, then there's going to be a huge capital gains between $50,000 and $2 million. And between federal and state, you could calculate roughly and say it's going to be a third of what that is. So it's going to be pretty significant if that happens. But there is discussion about doing that. And I think there's going to probably be discussion about changing a number of tax laws that we currently have. And so be mindful of that. Keep an eye out for that. If it happens, contact your advisor and just go over your current plan and see, is it in the best shape it could be? Is there something that could be done to tweak it to accommodate any changes that might occur? Okay, so as far then as passwords, because that's an item that's on the subject here for today, what happens? A few years ago in 2017, and it became effective in 2018, California passed a new law And it's the Uniform Fiduciary Access to Digital Assets Act. So it's Uniform Fiduciary Access to Digital Assets Act. And it's in the probate code section 870. And what it says essentially, and I'm just going to break it down, is that a person may, they have all of their passwords, their user IDs, that sort of thing. They have their bank account numbers, they have their social security numbers, they have their IRA numbers, their retirement, they have all of these insurance policy numbers and so forth. They have all of this information and they can put it on they can lodge it somewhere, like an iCloud or some type of, computer generated storage facility. And there are a couple that have established really storage sheds, storage portals just for that. Dashline, DASHLINE is one of them. Keeper is another one of them. I personally don't know enough about them to make a recommendation or would not make a recommendation one way or the other. There are others also, and there's a password to get into their site. And then with that password, the person would have access to all of the passwords, all of the account numbers, that sort of thing. And in some cases, all of the documents. Documents can be uploaded too. So there's a storage of documents, and then there is a schedule of digital information as well, like passwords. You want to be careful who you give that authority to. What the code says is the authority, usually it has to be in writing, the person you're designating, and then the person that's got the information that is trying to be accessed will probably want to see it. So it could be your executor under a will. It could be a trustee under your trust. It could be an agent appointed under a power of attorney. But the holder of the information is going to want to see copies of those documents and to see that those documents specifically say that John Doe or Jane Doe is entitled, and I hereby grant that person, Jane Doe or John Doe, the right to access my personal information, such as that. And then they're going to want usually a certified copy of the death certificate as well as the original document before they're going to allow this person to have access. But once that person has access, they can go in and they can check all of your accounts. They can check to see if your utilities are paid and current. They can, everything that you have listed in there. They then would be able to readily review and get the current status, and then take whatever reasonable steps are necessary to keep everything going on a smooth level while they're handling, if they're a trustee, while they're administering the trust and getting ready ultimately to distribute the assets out. Because until the assets are distributed out, they're within the trust, even though the settlor has died. And the successor trustee is the one that has the responsibility. And they have a very huge responsibility because it's a fiduciary responsibility. So it's of trust, it's of competence and confidentiality and fair treatment of the beneficiaries that these trustees have the duty to perform. So now I always recommend, let me backtrack on that because I don't always recommend this, but many parents, when they're selecting who they want to be trustee of their trust, when the last of the two of them goes, will say, well, should we start with the oldest and work our way down? John, Joe, Susie, Jane, Or should we start with the one that's got the highest education degree? The one that, has a mass MBA. And then, even though that one's the youngest one. And then, order it in some sort of, fashion that way based upon education or competence or closeness to where they live, or ones that they're closer to and that have been attending them while they're in their, later years. That often happens. One child will actually move in with a single remaining parent, and they will become like a caregiver to that parent. And very often that parent, has a new relationship with that child, and it's a very grateful relationship. And they want to prefer that child by a larger gift, at the time they die. So they want to amend their trust, let's say, to say, gee, you know what? Andrew's been with me. He takes care of me. He goes to the store. He pays my bills. He, does everything for me. And I couldn't live without Andrew. And I want Andrew to get 50% of everything that I have. Plus, I want Andrew to get this house because he's living with me, and it's not likely it's become his house. And now, if Andrew's the one that picks up the phone and calls the lawyer and says, gee, mom wants to make a change to her trust. Can I make an appointment for her? And then Andrew drives mom to the lawyer's office. Andrew wants to sit in the conference room with mom. Andrew wants to write the check to pay the bill. Those are all red flags for the lawyer. And the good lawyer, the experienced lawyer that's been around, isn't going to want to do that, because that looks like control. That looks like overreaching, even though it seems to have really good aspects to it. I'm being helpful. It's a caregiver sort of status. In California now, because so many caregivers were getting gifts via late changes to wills and trusts made by the person they were taking care of. And litigation was starting to, ensue because family members were getting cut back because this new caregiver was coming in. Somebody, mother or dad, hadn't even known, 2 years earlier. And now all of a sudden they're getting preferred gifts. And it was causing a lot of litigation. So there's some time limits now on caregivers. There's some definition of caregivers, and family members can become caregivers. And so they have to be very, very, very careful about all of this. And oftentimes when a lawyer is doing a modification or an amendment to a trust for a parent that is in that situation, where they want to change a prior estate plan to now prefer somebody that is there, that lawyer may say, to be on the safe side and to make sure that any challenge can be successfully defended, I want you to go to another attorney, get an independent, and have that attorney talk to you and sign. There's a statement that they sign that they have talked to mom and they've made an independent judgment that mom is acting on her own accord under proper circumstances and that it's okay. If there's any question about the capacity of a client, we always want to have contact with that client's doctor. Ideally the personal physician that would know, the whole spectrum of treatment that patient client is receiving, to get an opinion there as well as to the capacity. And these are all protections to try to ensure that when mom makes a right decision, that decision is going to be protected later on in the event there is a contest or litigation. Speaking of contests and litigation, because that often comes up, just about every trust and will has a paragraph that talks about anybody who contests this trust, I leave them $1. That the old days used to say $1 because that was some consideration. But if they successfully contest a will or a trust, the whole thing goes out, including the provision that they, lose the $1. But if, for example, and I've seen this, and that's why I mention it, because this is not an uncommon occurrence. Parents will want to choose, for various reasons, to prefer one or more children over the other children. And sometimes there's a reason why they may want to just cut out that child. Very often they may say, that child I haven't talked to in 10 years and they're on drugs and they're substance abusers and they've been in and out of jails and prisons, and I don't want him to get a penny. And I don't want his kids to get a and we talk about that, talk with them about that. Somebody out and go ahead and contest it because I have nothing to lose. I don't get anything anyway. So sometimes if you really want to avoid a lawsuit, the question is, what do you put in there and give to somebody to make it enough to dissuade them from bringing a lawsuit to challenge the document? And that is a concept that we do work with also, because that is a practical concept. If they're given $50,000, but if they, run the risk of losing it by contesting the trust, they may think twice about that, and I use that just as a hypothetical example. But let's see, in evaluating assets, another reason to look at your trust or your estate planning documents is values change. Often they're going up. And it's a good idea to have a fairly accurate, up-to-date idea of what is your estate worth. And even though IRAs and KEHOs and retirement programs are not put into a trust, their values are important because it does affect what is the size of the estate, even though it's not a trust asset. And so it's always good to look at that. So changing laws affect a program. Family situations affect, an estate plan, and values change. I mean, real property dollar values change, or, even increases or decreases in, brokerage accounts and so forth can affect a change. And it's not uncommon as people mature to see an increased interest in philanthropy. This does happen. And so therefore, people often want to make some changes and allocate a portion or a percentage, a part of their estate to some type of philanthropic interest that they have developed as I say, have matured. And they feel that their children or their other family members, other beneficiaries are now stable, well able to take care of themselves, and they'd really like to express their gratitude to this charity or this philanthropic enterprise for benefits that they may have received. And so let me see. Oh my God, it's 12:15 by my clock. Am I out?
Well, no, I mean, if you got a couple more items to cover, Bob, that's fine. You can
All right.
go a little longer.
Leave instructions for your trustee and your executor. They can go on a hard drive. You can put in, a USB port, for example, where you plug it in, and then you can just hand it to them. It's like a fob. And so you can back up all of your information on external hard drives. and you store those in a safe place. Often it's a safe deposit box. I used to tell people when we just, did wills and so forth, days, if you're going to keep it at home, the safest place to keep it is in the freezer of your refrigerator, because that's the last place to burn. And so if it's in the freezer, it'll last the longest if there's a fire in the house. I don't say that anymore, but the point that it does make is, where is the safest spot in a house that you can put these items? And it could be different for everybody's house. But a lot of people put things in safe deposit boxes. But again, to gain access to a safe deposit box after a person dies, unless you've made somebody a co-owner of the box with you, and therefore the co-owner can go in at any time, then they're going to need a certified copy of the death certificate and proof that this person has the authority to go into your box. And somebody from the bank will be there, and they inventory the box and that sort of thing. But some people have safes at home. But again, there may be combinations, there may be keys to these safes. So what do you do? If you have one trusted person, yes, you do it. But remember, we're all human. People can have accidents. They could be killed in a crosswalk. A plane could go down. And the question is, do you do it with two people or just one? So these are things to think about. And when you're making your choice. And one last thing, I had a
You
family.
lost your video.
Oh, okay, 1 minute. It looked like somebody was.
Bob, you there? Whoa. Lost everything. Jocelyn?
I don't know where he went.
Yeah, I don't know.
Comment. On the bottom of page 2, he's down at the bottom
Yeah, I know that.
and he's unmuted.
He's on video too. I mean, he should.
Well, if he got booted somehow, I would imagine he's probably trying to make his way back in.
I think he hit on an important thing. I'm doing a little fill in here while he's waiting for him to come back. Is where do you store all your passwords? For your spouse or for your family. You've got all these passwords to the bank, to your checking account, savings account. Every one of us probably has 100 passwords. And where do you store those? That's a safe place that your family knows of or your spouse knows of. And I think when we get to the Q&A, it might be a good chance for us to share what are the better ideas of how to store passwords. And I'll
There
share.
he is. He's back.
Is he? Oh, Bob, you're back.
He's muted though.
I'll ask to unmute him. Hang on.
Okay, now you can hear me?
There we go.
He disappeared for a minute or two.
Yeah, a spam call came in.
Oh,
I apologize for that.
I filled in for you, Bob.
Okay. I'm done.
No, you're not done.
Oh, okay. Questions?
Let me just finish where I was running with this. Is that one thing I have done for my computer at home with Susan is I put a little folder on the desktop of our computer that says when I go bye-bye. And inside that are all my passwords. And so Susan knows if I croak, she can get access to every one of my passwords. And it might not be the safest place in the world, but it's safe enough for us. It's not 100% risk-free, but it's safe enough for us at least. So anyway, questions to Bob.
William has a question. William, you're going to need to tap the microphone on your screen to unmute yourself. If you tap your screen, there should be a little microphone image with a line through it. Kurt, you want to send him an unmute request? That might be a little easier.
Who was asking the question?
William, and I see Finn's hand. Finn, you'll be next. Rita, I see you.
I'm looking for William. Oh, there he is. Asked to unmute. There.
You should get a little notification, William, that the host wants you to unmute. Say, okay. There you go. Go
Okay.
ahead and ask your question.
Okay.
Can you hear me now?
Yep.
Okay. Hey, Bob,
Yes,
can you hear me?
I can.
Okay, I just had a quick question regarding what kind of a literature, like a book or other literature, would you read to kind of become more cognizant of what this living trust is about? I know that before you go to the attorney, I kind of like to have an idea what it is I'm talking about.
You know, there probably are a lot of books out there. Honestly, I would say if you were to Google, you know, what is a trust? What is a will? What are the
Okay.
differences? You probably would get to some sources pretty quickly.
Yeah, well, I see these sources, they run from almost $500 to like $30. So I guess I'm having a little trouble deciding. I mean, I don't want to spend $500, even $100 if possible, for something that could just give me kind of a simple plan for what it is that the trust includes. So I understand they're doing the Google, yeah. It's just a pretty wide spectrum of references.
Trust for dummies.
Yeah, I'm looking for something for dummies. You got
Like
it.
us,
Yeah, I don't know that there's one out there. There's just there's a lot of them.
Right. Mhm.
And I have never really, you know, I've never really had the occasion to actually refer somebody to a book like that,
Uh-huh.
honest.
Okay, just thought I'd ask, and you know,
Sure.
the attorney, the living trust kind of seem like they have different parts, and family trust, IRA trust, personal
Oh, there's a lot of
trust,
different kinds.
all those things, and so frankly, I get a little overwhelmed when I hear somebody talk about all these things.
I see. I know when we get a call from a potential client or a contact, we ask them several questions. We want to know, are they married, single, widowed, divorced? And then we have questionnaires that we will email to them based upon their answer to that question. And the questionnaires are pretty good because they ask them to go and check their IRAs and their KEHOs, their retirement program, their pension program, and check who are the current beneficiaries and are there backup beneficiaries, like alternate beneficiaries, and on accounts that may be in their name. Is there a pay on death, you know, provision? Or is there a co-owner of the account or somebody with authority to write on the account? Getting them to check to see exactly what have they done, if anything. And to put the idea in their mind that maybe there are different ways of handling these things and items that do need to be done.
Yeah.
So
Okay,
that's how we generally approach it.
okay, you're actively engaged in these living trusts, right? Are you retired?
No, that word's not in my vocabulary.
Okay, very good, all right. Decided that's right.
I don't know how to spell it. Thank you, William.
Unmute. And I saw Janine and Sidra. Arlene, I see you.
Hi. Hello.
Okay, Bob, Prop 19 basically had two major effects. One was for the fire people in fires, and for those of us who didn't want to see Prop 13 destroyed. It seemed like the state has for years been trying to fight this thing. Is it any likelihood that, is it likely this could be taken to court? Or does it have to go through another proposition to
Yeah,
get overturned?
right. That's an excellent question because there is a lot of discussion exactly on that issue. And I was on a conference call with several members of the Board of Equalization that are very involved with this. And this one gal, she represents 21 of the counties in California. She's a board member that represents 21 counties. And even amongst the counties, there's not an agreement as to how to approach some of these things. But a number of people would like to, try to undo the Proposition 19 because they are now realizing that it has stripped away, in fact, some very material aspects of Prop 13. And it's a chipping away that's occurring. And but this was a big chip. So on court cases, will they overturn it? Propositions don't get overturned very easily in court. Seen upon that as a highly likely result. But there are so many loose ends that have not been determined yet that are going to take more affirmative action from the legislature to try to clean up and to give some sense, some sense to, so to speak. And it's going to take a while. It's not going to happen very quickly. And so there's not a unified gathering, so to speak, at this point to try to go in and get the legislature to say, gee, we want to enact something that, really has the effect of removing it. But that may gather steam as more people become aware and more people are affected by it.
Thank you.
All right, Rita, go ahead. And Janine, you'll be up after Rita.
Are we talking me, Rita?
Yes, you, Rita.
Okay.
Hi,
Well, now-
Rita.
Hi, Kurt said there were three of us, so I wasn't sure which one. Okay, in my trust, having gone through watching my sister, the executor, squander and misuse her power, I made my children, I only have two, and I made them 50-50 beneficiaries. I also put a clause that said if they are a beneficiary and an executor, they do not have access to any fee. Where my sister not only hired an attorney that she didn't need to, but she also took an exorbitant fee. And I thought that would be the best way to keep my children from abusing their powers if I made them equal partners and no fees if they were beneficiaries. Is that a smart thing to do?
So let me ask you a question. You use the term executor. That's used with a will. Trustee is the term we use for trust.
Yeah,
So
they're
did
both
you-
equal trust, 50-50 trustees.
Okay, so we call that co-trustees. They're
Okay,
co-trustees, right?
yes.
You know, I have seen that work well, and I've seen that fail horribly. I don't know how well they get along.
They don't.
They
But
don't.
I told them if they wanted to use all their inheritance fighting each other, that was up to them. I was out of it.
Oh, okay. So ordinarily, if I had a client that told me that they don't get along, I would say I would not make them co-trustees. As a matter of fact, I probably wouldn't make either of them or recommend either of them be a trustee. I would say get an independent third person trustee. So just before my phone went off, I was about to say that I had a client, they had 4 children. And what they did was they didn't name any one of their children as trustee. They named a nephew. He was kind of a businessman as trustee. So when the last of the 2 of the parents died, all 4 children were in my conference room with their cousin, who was the nephew. And I said to them, you should get on your knees every night and thank your mom and dad for naming your cousin as the trustee. He's going to be doing all of the paperwork. He's going to be doing all of the legwork. He's going to be spending all of the time. If property is sold, he's going over the listing agreements, the showing of the property, the offers, the counter offers, the escrow, all of that sort of stuff. And you won't be bothered with that. He'll be handling the tax returns, final returns for your parent and the year of death, the tax returns for the trust while the trust is in administration. You've been spared all of that. You should thank your parents for not having asked one of you or 2 of you to be doing this, because the other 2 or 3, they'll say, why is it taking so long? They shouldn't be getting any money. And, you know, all of these sorts of things. So in your case, Rita, I would say, as a very practical matter, give thought to maybe modifying, amending your trust and putting in somebody else. And I always say name 2 in succession, because something could happen to the one you name, the primary one.
But don't they
You might be doing your kids a huge favor by doing that.
Well, my oldest daughter has a paralegal degree and all kinds of, my kids are well educated, but they get along as long as they're not together more than 2 weeks. They both understand that there is no reason for them not to just settle this out of court, because it's their money they're spending, not mine. So, and I don't you have to have someone younger than you that you can trust? I don't know anybody younger than me that I could trust. So I thought I'd let them figure it out
That brings
themselves.
up something, maybe Bob can mention. What do you recommend are good executors of estates?
You know, I think if you look at what are their duties.
Besides, let's say, besides family members.
Oh, well, in this case, we just cited, the nephew was a perfect one in that family. Okay. And he did a great job. It went on for a couple of years, did a great job. But so it could be some other type of relative. It could be somebody who's a friend that you have known for many years, but somebody who is competent, capable, trustworthy.
What about a fiduciary?
Yeah, absolutely. Fiduciaries. There are professional fiduciaries, banks, credit unions, savings and loans. You know, they all have trust departments, many of them.
But don't they cost so much money?
Yeah, they have a fee chart, all of them. But there are some private fiduciaries that I have worked with that have been really good. And, you know, people don't realize fiduciaries have to get their hands in the dirt. You know, they have to get down there. They have to go out and talk to tenants. If you've got an apartment house, they, you know, if they're going to raise the rent or they're going to, you know, ask a tenant to move because you're taking the property back and you're going to restore it or you're going to remodel it or whatever you're going to do or sell it. And they're spending a lot of time. I had a case where there were two brothers who were co-trustees. It was the worst thing that ever happened. And they hated each other. They were okay. When it started. I came into it to represent one of them. I didn't draw the documents or anything like that. But what happened was their wives would meet for lunch once a month. And the wives would say, well, we're acting as secretaries for our husbands, the trustees, so we will take a fee for that. And so the wives were getting paid a monthly fee. They were having lunch monthly, and they had a falling out. The wives had a falling out. And then that overflowed to the brothers, and who had been friends. And then the brothers didn't talk to each other. One would say black, the other would say white. One would say, I'm signing the tax returns. The other one saying, I'm not, and that thing ended up hundreds of thousands of dollars later before it got terminated. So, it's your gut that will tell you, I always believe the gut's a good rudder for life's direction. And your sons or your children, Rita, and you've just heard me talk about some experiences that I have personally seen. And, you plug that all into, the thinking, and then your gut will tell you what to do. And it may be that, the family relationship between the two is overwhelms any other considerations.
Okay,
And-
thank you.
Janine, go ahead, and Sidra, you'll be after.
Okay. You hear me?
Yep.
Okay.
Yes.
I have a question, Bob. We have a trust, that's taken care of. We have the executor, that's taken care of. I'm talking about the day-to-day things when we can no longer do them, like write out the bills, maintain the house, make sure the pond men come to clean out the waterfalls, stuff that I do now. If some point I can no longer do that, what's a good source? We don't have a sibling close. We don't have somebody that can take over that. What's a good source of finding somebody to take over the day-to-day stuff that, you don't want to Google, who can take care of my affairs? It sounds like an open invitation to a scam. Do we do that through our lawyer? What's a good source?
Lawyer may have some references of maybe some private fiduciaries that he's worked with. The lawyer probably isn't going to be wanting to handle the bills and things like that
Right.
for you.
Right.
As far as being able to recommend one or two people, the lawyer may well be able to do that.
Oh, okay. Because you just don't want to hand it over to somebody that you don't know without some kind of reference.
No.
And at that point, you'll be less capable of knowing if they're good or bad.
Right. Exactly.
Okay. That's
So
good.
if you have a trusted friend now or friends that you can talk to about this may be a potential down the road, would you be willing to do it? And I think you need to speak with somebody if you're going to be choosing the person to make sure they will be willing to do it and that they have an understanding of just what they're getting into.
Yeah, we don't have anybody that lives locally that could take it. It would have to be somebody local that could sort of be here on a semi-regular basis to make sure when the bill comes in, it's taken care of, and this is taken care of, and the spot on the garage just gets repaired, and that type of thing.
So go to somebody that you respect and that now to see if they would have a recommendation or two.
Mm-hmm. Okay.
So I would do that.
Good. Thank you. Appreciate it.
Sidra, go ahead, and Arlene, you'll be next.
And then after Arlene, we probably need to close out.
Bob, thank you very much. This was really helpful. I have a question, and I just got bumped off of this, so I may have missed an answer that you've already given. When it comes to a fiduciary, I don't have family, and my friends now are as old as I am, so I'm not going to ask them to do this. But how do you find a fiduciary, or how do you check one out? Are they licensed? Or?
Yeah. Yes, there are licensed fiduciaries. Banks do fiduciary work. Bank of America, Wells Fargo, Union Bank. I'll have to tell you, of all of the banks, the one that I have always really liked, and I think is really toward the top of the list, is Union Bank. I've seen them really do some good jobs with some complicated matters. Not to say that the others don't or wouldn't, but that's been my personal experience. There are private ones locally in the South Bay. There are some private fiduciaries. There used to be some in San Pedro, in Manhattan Beach. There are a number of them. And, I could probably try to get a couple of names and numbers for you if you wanted to email me.
That would be great. Thank you.
Okay. You're welcome.
Arlene, go ahead. Make sure you unmute yourself first.
I just asked her to unmute.
Okay.
Arlene, I'm,
Yeah.
there you go.
There she is.
I did it. Bob, thank you for all your help today. I am 77 and have never done a will, a trust, or an estate plan. Who should I go to? Should I go to you?
Sure.
Oh, okay. How do I do that?
Let me give you a phone number and you can call and speak with Chris. And then Chris would ask you, are you married, widowed, single, divorced? And then she would email you a questionnaire. And then we would set up an appointment for you to come in to have at least an initial conference.
Okay, but she could give me, Chris is a woman?
A woman, yeah.
Okay,
Yeah.
would she be able to give me an idea of how much this might cost?
I can tell you that probably right over this speaker.
Okay.
Generally, what we charge for individuals is $2,500.
Wow.
And that includes the trust. This is for a trust. That includes a trust. It includes a pour over will. It includes a pour over will is a will that says if it needs to be probated and there are probate assets, when it's probate closes, pour the assets over into the trust, make them a part of the trust, and distribute them pursuant to the terms of the trust. We do a certification of trust. We do a comprehensive transfer statement, transferring all the personal property into the trust. We do an advanced healthcare directive if you don't have one already. And then we do a durable power of attorney for financial matters. So we do, and then if you own property, we do the deed to transfer the property into the trust. So that's all about $2,500 plus the recording fee. If it's LA County, it's about $50.
Bob, can you share Chris's phone number? There may be other people besides Arlene that might want to.
All right. So Chris's phone number is area code 310-545.
What?
6565.
Can you repeat?
So again, it's area code 310-545-6565. And then if it's a married couple, the fee is about $3,500 plus recording costs.
Well,
So-
mine is so simple. I don't own any property.
Oh, okay. So we would talk about it to see what would be the best way. You might not even need a trust.
Well, okay. Anyway, thank you so much.
Well, let's have a nice round of applause for Bob, huh?
You bet.
Bob, so much.
you
Wish
all.
we could have gotten away with
Thank you very
35.
much. Yeah.
You've been just terrific. And I can't think of a better way to finish this out than to have Jackie's raffle. So I'm going to turn it over to Jackie.
Right.
And Sidra. I mean, not Sidra, Jocelyn, sorry. I was looking at
Again, Bob, thank you so much. I learned a lot. I do have a will, a trust, and so I may need to have it updated a little bit. Because I own 2 houses. Unfortunately, I have a lot of real estate. Okay, here we go.
I lost it.
This is what we're raffling off, 2 of these. One says, I'm dead, now what? And the other one is a paperback, and it's the same thing. So it's for all our little, and I'm gonna mail them out to you. So the names are in this bucket. And you have to answer the question. There's 2 trivial questions, okay? And they're fairly easy. Everybody's a candidate, so here goes. Oops, one fell out. Okay,
Yeah.
that one's blank. Patsy.
Unknown.
Pat Cottrell.
Hello.
Are
Hi,
you there?
I
Are you
am.
there, Pa- Are you here, Pat Cottrell?
I am here.
Okay, I'm gonna have a question for you.
Okay.
What famous baseball player married Marilyn Monroe in 1954?
Joe DiMaggio.
Thank you,
I didn't hear that.
Joe DiMaggio.
Joe DiMaggio. You're right.
She got help on that.
Yay. This will be coming to you. I'll mail it out. Okay, the next one. Karen. Karen, are you here?
Yeah, to tell her unmute. Tell Karen to unmute.
Hang on, where is she?
There she is. Okay, Karen Thompson. I know she's
I'm looking for her.
she's multitasking.
She was on. There she is.
There she is. Karen. Hi, Karen.
Hi.
I have a question for you. To win this beautiful book, this is the question. What month, day, and year was Pearl Harbor bombed?
November 22nd.
No.
No.
How about December 7th,
1942.
1921?
Okay, this is only for Karen.
December 7th.
1921.
Nope.
It was December, but it was
41.
21. It was
It's the
41.
year is wrong.
41.
42.
No, 41.
Okay, Karen, what was it?
Who?
I said December 7th, 1941.
You got it.
That's it.
1941. So this will be coming to your home. Okay.
All right, thank you.
I think everybody needs to get their affairs in order, no matter what age you are. And Bob, do you mind, Bob, if we kind of put a little blip on the newsletter with your phone number?
No, that's fine. Fine.
Oh, great. Okay. So that if anybody needs to.
Hey, let me say one more thing
Sure.
before we close. As soon as you hang up, go turn on your TV to the NASA channel, because the Mars rover Perseverance is supposed to land at 10 minutes to 1. And that's
Yay.
the one that I talked about when we went to JPL.
Yeah, your relatives are involved in that.
That's a good reason for us to finish out this call.
Okay. Well, thank you again, Bob. Thank you, everybody, for being here today.
Thank you.
Thank you all.
Enjoyed it. Very good. Very good.
Thank you, Bob.
Thank
Thank
you.
you, Bob.
Everybody, a
Have a
great
great
meeting
day,
as
everybody.
usual.
Okay.
That's good.
Bye, everybody.
Bye-bye.
Bye. Bye,
Thanks,
Kurt.
thanks for being pet pioneers. Adios.
Kurt,
Yes.
my short-term memory. Who won again? Karen and Rita. No, who won?
Rita.
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 Okay.
God, I'm glad I'm not the only one with the crappy short term.
Yeah. I'm only 62. Okay, thank you, guys.
Okay, bye, everybody.
Bye.
Bye. Bye.
Bye.
Stay safe and stay healthy. And watch out
Okay.
for those COVID shots.
Oh,
Oh, get a good one from the Veterans Association
Yeah, I can't
instead of
afford,
a grocery store.
I can't afford that, Archie. KD6 ATJ.
KD6OLH, as you can
Signing
see.
off.
Hey.
Likewise.